Well, good afternoon. Ever since we had our first class in law school, and even before then, we always knew that what judges say matters. But does how judges say what they say mean just as much as to the persuasive value of the discussion? How much does how they say what they say matter, and how much are they concerned about it? Every judge would answer these questions differently, and so today we're going to have a range of views from esteemed jurists and the Illinois Bar, a diverse judicial panel today. For the next 50 minutes, we're going to be talking about judicial opinion writing. And I can assure you that it affects everyone. It's not just judges. We're all connoisseurs of judicial writing, but we have a lot of students here, and perhaps one day you'll be a law clerk. We have professors here who are teaching the law clerks, and we have judges here. And of course, we're all interested in what judges have to say. So let me introduce you to our panel. I'm humbled to be the moderator, but let me introduce you first to Justice Mary Jane Tice. She's a justice on the Illinois Supreme Court, and in her long judicial career, she's done what very few judges do in any jurisdiction. She's served on every level of the judiciary in Illinois. She was a member of the appellate court for 17 years, and since 2010, she's been on the Supreme Court. And prior to that, she's been the past president of the Appellate Lawyers Association of Illinois. In that time, she has drafted and released 435 judicial opinions, full opinions. That's 319 majority opinions and 37 dissenting or concurring opinions for the appellate court. And since she's been on the Supreme Court, 61 majority opinions and 81 dissents or concurrences. We also have with us Justice David Ellis. Justice Ellis began his legal career in private practice in Chicago in 1993, where he specialized in commercial litigation and constitutional law. And in 2007, he began serving as chief counsel to the Speaker of the Illinois House of Representatives. And you may know him most for his service in 2009, where he served as the House prosecutor who tried and convicted Governor Rod Blagojevich in the impeachment trial before the Illinois Senate. He was elected to the Illinois Appellate Court in 2014, and since that time he's authored 99 opinions, 96 for the court and 3 dissents. And most interestingly, but perhaps not as interesting, he's also authored 13 novels. He's won the Edgar Allan Poe Award and was a finalist in the LA Times Book Prize for Fiction, and he's co-authored 4 suspense novels with James Patterson.
Ooh, wow. He knows how to find the book.
You've got fans.
I'm curious about the rest of it. James Patterson.
But it's the 99 opinions that he really is proud of. We also have with us today Judge Ben Goldgar. I want to pronounce that right. He's a judge on the United States Bankruptcy Court here in Chicago. He served in that capacity since 2003. Before that appointment, he spent 7.5 years with the Civil Appeals Division of the Illinois Attorney General's Office. And before that, he was with a large Chicago firm for 13 years, where he did commercial litigation and appeals. He received his A.B. from Brown and his J.D. from Northwestern University Law School. And 127 opinions he has authored. Now he has a stack. He says it's probably close to 2 feet high of orders that he's written that don't amount to full opinions, but they are innumerable. And I'll be serving as your moderator. I'm Kevin Ross. I'm a member of the Scribes board, and I'm a judge on the Minnesota Court of Appeals. So I'm the interloper here in Illinois. I hope you don't throw me out just because I'm a Viking. As a fan, you can tell I don't have any ethnic connection to the Vikings. I previously practiced constitutional law and employment law for a Minneapolis litigation firm, primarily defense work. I clerked for 2 federal judges, Judge Donald Lay, former 8th Circuit Chief Judge, and Judge Paul Magnuson, who was Chief Judge at the time of the Federal District Court in Minnesota. And I've been serving for 10 years on the Minnesota Court of Appeals, and I've written 715 judicial opinions and an additional 68 separate opinions that are dissenting opinions. And and concurring opinions. It's not to say that Minnesota lawyers work harder than the Illinois lawyers or judges. Certainly not. But you'll see, if you've kept track, and I'm sure you have, that's 1,444 judicial opinions between the group of us. So let's talk big picture. That's a lot of opinions, yeah. That was sort of polite applause. You were all thrilled about the 13 novels. Judicial opinion, so that's very nice. All right, well, okay, so we're going to talk about judicial opinion writing, and let's talk about the big picture first. And we're going to clip through as many questions as we can so we can cover as many topics as we can in the next 50 minutes. So let's talk about the purpose of a judicial opinion. And there's a lot of views about what a judicial opinion is designed to do, where it fits. And I can suggest that it probably has different purposes for different audiences, and we'll talk about audiences, but first let's talk about purpose. Taking a bird's eye perspective, I'm going to ask each of our panelists to spend about 2 or 3 minutes giving their impression about what is the place of a judicial opinion, the place and value in the case, in the legal landscape, and in society at large. And Judge Goldbauer, why don't we begin with you?
Well, as a trial judge, I have a different take on this because nothing that I do has any precedential value. In fact, it isn't even binding on me. I can change my mind even in the same case if I want to. So it's a little bit different. My stuff doesn't live on after me particularly, and it has at best persuasive value, and some would say not even that. Depends on the opinion. The value of my opinions in society probably limited. The value to the parties in the dispute could be considerable. And I would hope, and I imagine we'll get to this point later, the value to a reviewing court, particularly since I'm a judge on a specialty court whose decisions are reviewed by a generalist court, the value to the reviewing court could be considerable, quite frankly. I try, since I have this option, not to publish. This is why I have a big stack of unwritten or unpublished orders that could have been opinions had I only slapped a caption on the top, and only 127 opinions. And that is, if I am not doing something that I think either advances the law or applies settled law to an unusual set of facts, the parties are going to see it, and a reviewing court, if any, but nobody else will. So that's how I look at it.
Justice Tice?
Well, I have spent 20-some years reviewing courts, and so I have thought a lot about how the opinions we write affect the individual litigants, the lawyers, the trial judges, the judges on courts below, the bench and bar generally who are going to read these opinions. To some degree, I now have my master's at the United States Supreme Court. I'm a little concerned about them, but maybe not so much of a lot to me. But certainly those are all the audiences we're talking about. But sort of in a big picture, I've been thinking more and more about how our ultimate audience is really public. There was a time when we wrote opinions, and they were all in those lovely books that every law office has, that you have your picture taken in front of those books. Well, we don't publish books. Here in Illinois, we stopped publishing our opinions about 5 years ago, and so our official opinions are, in fact, those that are filed electronically on our website. And what we've begun to learn, and some states have tracked this, many members of the public are reading our opinions. Now, that, you might wonder why. I mean, I think we have to think about this some more, because this is kind of a new phenomenon. But in any case, I'm starting to think more and more about that there's a role that we have on explaining to the public, in other words, beyond the legal readers and the litigants themselves. And what that means and how we explain a consistent rule of law, I think that's something that we need to think more deeply about, and those are kind of the issues that I'm concerned about right now.
Thank you. Justice Ellis, the place of a judicial opinion in society, in the law, in culture.
You know what? I think that the most important thing that an opinion can do, when I think about where we are in our society and the place the judiciary has, I think the most important thing you can do in a judicial opinion is to give both parties a full and fair hearing. Both of those words are very important, full and fair. Full in that you cover all the arguments that they made. You let them know, you got your hearing. I heard what you said. We may not agree with your argument, but I can spit back to you what you said to me, and here's why we don't agree. And, of course, also be fair about it. I think that when the judiciary suffers in the perception of the public, it's when they think that we're not being fair, we're not being impartial. And the best way to do that, when you're an appellate judge, the only interaction you have is through what you write. So that's it. You don't go around, sometimes we go around and talk to members of the public, but for the most part, it's through this writing. So we want to show everybody, if you read an opinion, I would hope any opinion that I write and that any of us write, they could say, you know what, they went through everything, they gave him a fair hearing. So it was fair. In my experience in private practice, the most disappointed I ever felt in judges was not if I lost, because you lose sometimes. It's when I lost and I felt like the judge wasn't really paying attention to what I said, or didn't really get it, didn't take the time to grasp the nuance of what I was saying. It's when you feel like you're not getting your fair shake. We have to let everyone know that they got that fair shake.
Well, like each of you, before we get into the substance of the opinions in the sense of, when I say substance, we're talking mostly about style today. But let's talk about mechanics. If you could each, in about 30 seconds or so, lay out what are the mechanics, what are the steps that you take sort of from start to finish in the drafting of a judicial opinion. We'll start here. Justice Ellis, why don't we start with you?
Sure. In 30 seconds. I start by reading the briefs, and I take notes, any initial impressions I have. I read the record to the extent that I need to, which most of the time is the entire record. If there's any particular case law, if it's something where I don't know the case law as well, I might have to read some cases. And then I'll read what my clerk wrote. I usually have my clerk do a first draft, and I don't tell that clerk anything about what I think about the case. Not every judge does that. But I don't tell the clerks anything about what I'm thinking. I want their unabashed view. And then we compare notes and we try to figure out which one of us was right. Usually it's me, by the way.
It's amazing how quickly the clerk sees the light.
So Justice Tice, in the writing of it, so you've gotten to this place where you know what the outcome's going to be, and now you're going to the task of putting it down on paper. What are the mechanics of your approach?
Well, I think the first piece that I would start with always is try to spend some time really focusing on what is the issue in this case. And that sounds like it's so easy. Obviously, the lawyers are frame the issue. You just pick up what it says in the brief and away you go. But my experience is not every lawyer is able to frame that issue the way it should be. So the issue, to me, drives everything. So I'm going to spend a lot of time thinking as deeply as I can about what is really the issue. Also, I'm going to think deeply about where are we in this case? What is the procedure? Where are we? Is this a trial? Is this a motion to dismiss? Procedurally, where are you? And in a real nerd world, I'm also going to think deeply about the standard of review. To say standard of review to lawyers and students with their eyes glazed over. For judges, it tells me what I have to do here. What is my work? What is the extent of what I'm going to do? So before I begin anything, I really want to spend focused time getting my head in the right place to at least begin to analyze the issues.
Now, once you're done getting your head in the right place and you go to the process of writing, how do you do it? Do you engage your law clerks? Do you take a first draft yourself? What's the process?
I work with my law clerks in a very collaborative way. I have career clerks. One clerk has been on the Supreme Court 20-some years. Another one has been with me for 16 years. So I have 4 lawyers. We talk all the time. And we usually have a conference where I kind of we play with ideas for a while, and I ask them to start drafting. I don't wait until their draft is done. I talk to them every day and find out where they are, what they're thinking. They come into me and say, I don't think this idea works. And I say, okay, let's try this idea. And we move towards a draft until they give it to me, and then that's when the fun starts. That's when the editing starts.
Judge Golgar, what's your process? After you've come to a decision about what the case is going what the outcome of the case is going to be, what's the writing process?
Well, I sit down and I start to type, and when I'm finished, I stop. The actual writing isn't very interesting in that respect. I just do it. It's the deciding what the outcome will be that I think is the tricky part, and in that respect, I think I do things in a way that's probably the reverse of everybody else, and that is I pay absolutely no attention to the briefs. And I start with the record or whatever I've got. And remember, I'm a trial judge, so I'm dealing with different things. Sometimes it's a record of a trial. Sometimes it's just a motion to dismiss. I can look at a complaint without anybody helping me at all. I can decide whether it states a claim. It's not that hard, really, despite the efforts of lawyers to make it hard. And so, I'll come to the conclusion that I want to reach, and then I'll look at the briefs. I want to form my own impression first. And, I'll identify the issues. I still like little legal pads, and I'll put issues down, and I'll research them. And when I've come to a conclusion, I start to type. And when I'm done, I stop.
Now, do you have the assistance of law clerks?
I do. I have
And
two.
How do you engage them in this writing process? If you do the drafting, what part do they play?
I hate to reveal this kind of thing. I
This is what they've paid for.
I know. I feel like it's trade secrets. What I actually do is I assign different decisions to different people, and some things I just do myself with occasional assistance from them. And then other things they do in the first instance, and we talk about it along the way, and I get a draft, and I get the draft, and I rewrite it. So it's I keep the fun stuff for myself. That's what I'm.
Well, Justice Tice, you've had more time on the bench than the three of us combined. So I think you should be the first one to answer the question about audience. You've probably thought about this a lot. You mentioned it earlier a little bit. And the question of who you're writing to matters. And some probably take for granted that the judges are just writing to the parties, or the judges are just writing to the district court. But who do you envision your audience to be primarily, and do you have a secondary audience? And how, if at all, does being mindful of your audience affect the style, the vocabulary, and tone of your writing?
A lot. But the first part of the question is the complex piece, because we know that there are real people whose lives are going to change based on what we write, the litigants. In terms of the lawyers, the people who prepare the briefs, they've invested a lot of their energy and life into this case too. We're speaking to them. I'm also very concerned about speaking to trial judges. I was also a trial judge for 10 years. I love those opinions that say there's a 3-part test. And then you get on the bench and say, 1, 2, 3, I got it. I like to think about, I'm not sure I was doing a 3-part test anymore, but I like to think about how is this trial judge going to use my opinion, and then in the future, is this really going to work in trials? I understand that in a trial court you've got to worry about juries and you've got all these other things going on. Does this opinion really work for trial judges? Another audience that I think about that might surprise you are my colleagues. I need to get 3 other people to agree with me, or what I write doesn't really make any difference. And so in many ways, I'm trying to persuade my colleagues to join with me in the position that I think is the correct one. But as I said, I really am concerned about the public at large and how we engage the public at large. And I very much agree with David, the idea of acknowledging in the body of opinion specifically the losing party's point of view. I think someone once said that good opinion should be a love letter to the loser. And I believe that we should engage the losers so they have trust that they've been fairly heard. But as I say, I'm really passionate right now about this big idea of how are we communicating to the public so that they have a sense of what our courts do. And I'm thinking about ideas about explaining terms a little bit more than I usually do. Explaining the limitations on the court. We can't do everything. We can't just wave our hands. Something like to say, the standard review is abuse of discretion, move on, or should I take a few more words and explain to someone who's reading this that my authority only goes to a review of what went before. so the public is educated as to the process. There are many voices out there, and I'm trying to think about all of them as I draft.
Justice Ellis, I'm sure you're mindful of audience when you're writing novels.
Yep.
And you have to think about sort of the educational level of your audience. The vocabulary has to match in order for them to grasp and stay interested in it. Are you cognizant of any particular group or educational level when you're drafting judicial opinions?
Well, first of all, I'm not trying to scare the audience when I'm writing judicial opinions. I'm not trying to, thrill them. Not trying to keep them in suspense either. I mean, hopefully they get it when I'm done. What Justice Tice said I agree with. What I would add to what she said about audience is that I'm writing in addition to the public and absolutely to the parties. Parties come first to me. But I'm also writing for this body that reviews all of my work. You never know what cases are going to get taken, but but there are some cases that are obviously more difficult questions that you could imagine might be something that would be more likely to be taken, and I want to be particularly sure that I articulate my reasons and that I, so to speak, tee it up if necessary. I mean, I always take the position, I haven't been here long enough to have been reversed yet, but I don't even think I've been reviewed yet. But let the chips fall where they may if that happens. But my job is to at least, make it as clear as possible so that if it does get reviewed, people know exactly, where I stand. So I've kind of got a court below me and a court above me that I'm writing for at the same time, and the public.
Let's talk about effort. I had an occasion to be on a forum with a few individuals, one of whom was a Justice Scalia law clerk, and I was a little bit surprised to learn, and maybe you might be too, that they would spend, when I say they, all of his law clerks would gather with him, and they would pore over an opinion after it was completely finished. They would go after it word by word, line by line, phrase by phrase, and they would spend sometimes the entire day, an entire 8 or 9 hour day, and come back to it again the next day. And that's just for style, just for grammar and style. Those little pithy phrases you think just dropped off of his tongue, they worked on them, and they worked on the arrangement. I'm curious, as from each one of our panelists, how much effort would you say that you put into an opinion as to style and language, rhythm, flow? Quantify it for us. How many drafts do you go through, or how much in terms of time does it take when just that part of the editing? Judge Gogar, why don't we start with you?
I take time all out of proportion to my status as a trial judge. I have a very large caseload. This is the busiest bankruptcy court in the country. I have 5,200 cases. That's twice the national average. But I'm a fussy writer. I know that goes over well here. And I want to satisfy myself. And so I actually will go through lots and lots of drafts, even of these unpublished orders. And if I find a typo later, it's self-flagellation time, really. I have to be aware, because of the kind of job that I have, and I didn't understand this concept until I got the job, the expression, the perfect is the enemy of the good. I didn't know what that meant until I was a bankruptcy judge. At a certain point, you just have to let it go. And one of the things you learn is that what bankruptcy lawyers, particularly in consumer cases, want is they just want up or down. They're not looking for Marbury versus Madison. Does the debtor get to keep the car or not? But I spend a great deal of time on it, multiple drafts. I'll have huge stacks of paper full of red marks.
Justice Tice, when it comes to wordsmithing, what would you say, quantify the number of drafts of an average opinion?
Right before I came over here, I said to my law clerk in our parlance, "Press send. I'm done." and I really like to be paperless in my life. I try to be all digital and electronic. But I don't edit well that way, so I edit hard copy. This case, I think it is about this big, sitting on my desk, and I'm thinking, when I go back on Monday, I can't wait to dump all the drafts or do something with them because I have a lot of drafts. But basically, as I say, my clerk's draft it sort of continuously with me in discussion, and then I do the deep kind of editing. And yes, I am extremely concerned about language, word choice. I am terrified of saying something ever so much more than what I want to say. I've spent a lot of time, 17 years on the appellate court, where the Supreme Court would come down with a case and it would be your basic principle of law, but the iteration of it is just like one word different, and oh, God almighty, it's like there's a whole new law, and every case comes off because the Supreme Court obviously has adopted a new rule, and I just think somebody just chose a different word. So I'm very, very concerned about every single word and how exactly that it means what I want. My clerks, we do this for a very long time, then my clerks meet and rip apart each other's drafts for a very, very long time. And then bring back the next layer. I mean, that's always amusing after I've done tons of editing. I think I've really done a good job. Yeah. They've done even more, but that's been very helpful to me too.
Yes, there would be a lot of pressure on a Supreme Court judge because, you know, if I'm writing on something in the appellate court, there's probably a good chance there's about 20 other opinions in the appellate court somewhere in the state on the same topic. When the Supreme Court comes in on a topic, suddenly all that stuff grinds to a halt, and now that's the case we follow. And so every word really does matter. I have that, I guess, to a lesser extent. I'm a very fussy writer. I do 3 or 4 drafts of everything.
Do you send your opinions to your publisher for a look?
No, I don't. They would be probably bored to death. But it's, but you know, the tone really does matter. And I sometimes will ask my clerks, was I too hard on the trial judge, for example? And you have to be very deliberate. There are rare occasions where you might feel that the trial judge needs to be just slightly donked on the head. That maybe, you know, I can think of one case, I won't give any specifics, where the judge was extremely disrespectful to a defendant. I thought it was completely out of line, so I said that. I said it in a nice way, but I didn't hold that back. You know, you try to, you know, you try to show everybody the respect they deserve, and you try to hit that exact right tone, and you know, it's not a perfect science.
Every opinion has a number of parts. They're not always laid out in the same organization. They're not always specified as having these parts, but we know that every opinion has an introduction. Somewhere it will have the facts, whether they're woven into an introduction or not, the analysis, and eventually the conclusion. And there are different approaches to how an introduction is actually put together. And I've noticed that. I remember when I first joined the court, I was curious about formulas, and I went through and I would find jurists whose opinions I respected and their writing style I respected, and I noticed there was no real precise formula. Some courts have follow the same formula, but judges can usually kind of go off on their own, even if they have some type of a structure. I like to begin with a statement that includes what actually happened, maybe a grabber, you might say, in your world. This, by the way, this is a quote. My favorite opener in any judicial opinion of all time was this one. Judge Bowman on the 8th Circuit wrote this. This case begins with what we suspect and hope is a rare event in Iowa, the aerial bombing of a small business. And you got to know about the case, right? You can't stop reading at that point. Some judges in appellate opinions will just get right into the procedure and not even discuss the facts. Some jump right into the issues. So what do you hope to accomplish when you draft an introduction? Let's start with you, Judge Golgar.
Well, I often use, frankly, the kind of rote introduction that trial judges use. You know, this matter is before the court on somebody's motion to do something. For the reasons that follow, the motion will be granted, denied, ignored, whatever. And that tells you at least who the parties are and what they're arguing about in the broadest sense. It gives you a procedural context in a couple sentences, and it tells you the result. And that's often enough. Sometimes I will throw in something that explains why the result is being reached, and then sometimes I'll do more. Sometimes I'll set the scene. That is usually the province of judges on reviewing courts, but sometimes you just can't resist. I had a case involving a guy who filed an abusive involuntary Chapter 7 case against his ex-wife's landlord. This was part of a long campaign of abusive litigation, and when we came to the end, I wrote an opinion that started this way. Howard Leventhal uses the federal courts to make war on people who sue him or his ex-wife in the state courts. Sometimes he does this as retaliation. Sometimes he does it to buy time. Sometimes he does it to exert pressure. Whatever the motive, Leventhal's tactic is to, quote, make a federal case, unquote, out of everything, turning mundane state court matters into federal litigation, something he believes, wrongly most of the time, will intimidate his opponents and make them back off.
How many of you can guess how that case turned out?
He's currently residing in the Federal Correctional Center in Brooklyn, and I don't miss him.
When I first joined the appellate court, I was given a copy of a book by Ruggiero Aldisert. Some of the older guys might be not. He was the guru of opinion writing, and his book was called Judicial Opinion Writing, and it was the gold standard. And his instruction, and it's not like you were instructed, was that the first paragraph contains everything. The parties, procedural position, the issue, a short explanation of the result, of your reasoning for the result, and obviously the result. And so that's how I wrote opinions that way. It's very, very hard in a short paragraph to get all those ideas in, but that was the goal. And because I think one of the things that's good about that is it really clarifies your thinking when you start that way. Later in my judicial career, people, sort of the style changed, and people said, nobody reads opinions from the beginning to the end anymore because everyone's doing word searches. People are doing Lexis and Nexis. They don't care what it says in the beginning. And so I stopped being as concerned about that first paragraph. I'm still back now in line with Judge Aldisert, and have now decided that he was right. That the open paragraph is important. It's important that people, as I keep saying, there are people other than people doing Lexis searches who are reading our opinions, do read from the beginning to the end. But it also is your basic roadmap, which of course is the key to good writing, is framework and roadmap and structure. And to have your thinking clear enough that you can put that all in the first paragraph, I think is the way to send you as the writer on the road to a good opinion. So I'm back to doing strong, open paragraphs.
Yeah, my introductions will say everything. They may be more than one paragraph, but I'll explain whether I reverse or affirm and why. And by the time you've gotten to the end of the opinion, your thoughts have really come together and you can say them the best. That's when you write the intro, is after you're done with everything else, because then you can say it the best. I have had this conversation with Justice Hyman several times. You'll read a U.S. Supreme Court case that Kennedy writes or something, and they'll just sort of lay out what the case is about, and then they'll just keep going. You're like, well, wait a second, what's the ruling? I got to go all the way to the back? For some reason, that doesn't appeal to me. I don't know if I can articulate why, but it seems to me, if I tell you everything up front, I have laid it out for you, and everything else then can be put into context more easily. When you're telling a story that's going to be kind of long, it's not a bad idea to kind of give them the summary first about the information you're trying to give them, so then as they're processing it, they can always go back to what you said at the beginning.
Doesn't sound like a suspense author.
No, I don't like suspense in my judicial.
Well, it's interesting, Justice Tice and Justice Ellis, your approach. I follow a similar approach, and it was entirely by accident. And I spoke to a journalist who's a lawyer and who writes for a legal periodical in Minnesota, and I started figuring out why I write that way. If you look at how journalists write newspaper articles, you wonder why you get bored with long articles as they go. It's because they've told you in the first paragraph, intentionally, everything you need to know. And then the next paragraph, there's a little bit more detail. The next paragraph, there's a little bit more detail. But none of that's really necessary. And I learned the reason they do that is for space. Now it doesn't really matter so much because everything is electronic. But back in the day when things were done on paper and you needed space, you had to decide what are you going to edit. And they would just simply cut off the last paragraph. That's how they would do it until they had the right space. But that's why they build everything into the first paragraph. And I agree. I think it tells the reader not just where the case is going, but it gives them a synopsis and a sort of a vase, if you will, that you can pour everything else into, and then the reader can get it as they go along.
Yeah, if you've got an opinion that starts out and says, so-and-so sued somebody else, there was some kind of an accident or something, the trial court ruled this way, on appeal they argue this, and then you just say, for the reasons that follow, we reverse, and then you stop and go on. I mean, to me, that's not telling them anything. You might as well just leave out that last sentence and just not even talk how you rule.
Works for me.
Sorry.
I think it tells a lot of things. As I said, the parties, the dispute, and the result.
No, the rest of it's fine, but the last sentence is kind of a nothing sentence.
Reverse
If you're not going to
and
say
affirm?
why, you might as well just not tell them anything until the end.
Okay.
From now on, Ben, let's work on that.
I'll try to do better.
Everyone's got their own style.
I've
I think
been
that's
bad.
the part that I had the hardest time taking the reasoning and making it so concise it's going to fit in this one paragraph.
That's hard to
I think
It's
that's
hard
when
work.
I stopped following the Elder Cert model, because I couldn't. That's really difficult to do. But I think it best practices is probably good.
Well, at some point after we give the introduction, the facts have to come into play, and we've heard a lot today about the story, and we've heard from individuals who've told us how the story is developed by authors and how the story is developed by litigators. But now the court has to develop a story into the facts section. And so I'm curious, and we can start with why don't we start with you, Justice Ellis. Do you follow any particular organizational approach or writing style to help the reader best follow the story part, the facts section of your opinions?
My number one goal in the facts are the backbone of any case, and my number one, really my only goal, is to make it as easy to follow as possible. I don't really let any other rule get in the way of that one. I don't use titles. I try to use, I had a case involving like a foreign judgment and a military divorce, and it was petitioner and respondent, and my clerk drafted the first draft, and it was petitioner and respondent. I couldn't remember which one was the husband and which one was the wife. So I changed it to Jane and William. The whole case was Jane says this, William says this. Why wouldn't you do that? Why not make it easier? If you've got a double homicide and you've got 6 witnesses, and the witness got mentioned in paragraph 3 of the opinion, because in Illinois now we do paragraphs, right? And then maybe that person's name doesn't come up again until paragraph 24, remind us. I need to remind you who that person was. I can't just say Jones and expect you to go back and find where Jones appeared previously in the opinion. Just say, Jones, the neighbor who was on the phone when the shots were fired. Remember I told you about that before? Well, here he is again. Now he's testifying. Repeating information is okay. Anything to clarify, anything that makes it easier. I subordinate everything else to that.
Can you follow up?
I
Justice
think
Tice?
I start back with what is the issue in the case. Got to have a clear vision. What is the issue in the case? Because that's going to drive the facts. We don't need to know everything. There was an example of a case that I did not write, but a colleague wrote. It's a murder case. And it starts out that on this event, this day, some people had some people at their house, and here are all the names of all the people who were there. And they had a barbecue, and honestly, I said in the opinion, here's what they had to eat at the barbecue. And you're thinking, okay, what happens? And this turns out to be a murder, but you don't know who gets dead, and you don't know who gets charged, and it goes on and on. And that is the example I always use of, you have to know, what does the reader need to know? The reader doesn't need to know everything. Take out everything you can to make clear what it is the reader needs to know. Now, in the subtlety of all this, I often ask the question, well, inquiring minds will want to know maybe something else. If I read something and I can see a question mark hanging out there, and I'm a little worried that if I cut too much, there might be a question mark hanging out there. So I'm always looking for that too. But the other thing I try to do chronologically, write the facts, because I think that helps people read that. But the neutrality of voice, I think, is something we really want to talk about too. I have seen cases that talk about, on this certain day, the defendant shot and killed so-and-so. Well, that's kind of the point of the deal. Is this the right guy? So I think, this crime occurred, the defendant was arrested, this is what happened at his trial, is a much more neutral way to write, and I think you have to be very careful about that. The other thing is that I'm always very concerned about knowing myself, and you talked about the record, where do these facts come from? I want to make sure that they actually were in the record as someone testified, or they're in an affidavit, or etc. Where did each one of these facts that I'm writing come from? I had something this very morning where my clerk wrote something and I said, where does that come from? We tracked it down and it really was not admissible, so I'm not going to put it in my opinion. Edit only what we need to know.
Yeah, the point about clutter is a hugely important point. I mean, if you're reviewing the dismissal of a 6th amended complaint and the other 5 amended complaints don't matter, not only do I not want to tell you the dates on which all of them were filed, I don't even want to know they were filed.
Exactly.
I mean, it doesn't make any difference. Just cut to the chase. I'm always cutting dates out. You know, if you read a date in an opinion, the reader's going to assume that it's there for a reason. It's something important, and it ends up not being important. So
I have math anxiety and I get real upset.
yeah.
You're giving me numbers?
Yeah.
What am I going to do with these numbers?
No, absolutely.
Completely agree with you.
Yeah, absolutely.
Let's turn to talk about something that's sort of big and yet very abstract, and that's the idea of voice in writing. Something that really matters, of course, if you're writing fiction and the narrator has a certain tone or effect. I didn't really appreciate the concept of voice, I have to say, until relatively recently. I was writing a law review article on a late justice of our Supreme Court, Minnesota Supreme Court. If any of you are from Minnesota, anybody here from Minnesota? No one's going to admit it. Yeah, we did something. Justice Simonette, does that ring any bells? Justice Simonette is a revered jurist from our court, and if you knew him, you'd sort of picture him as sort of an Atticus Finch, Mark Twain, Oliver Wendell Holmes, Garrison Keillor, just all balled up into one. Just
Maybe he should be up here.
very elegant. Well, if he were living, he would definitely be here. But I was reading some of his opinions. He happened to come to work in the law firm that I was a partner in before I joined the court. He retired from the Supreme Court, joined our court, and I really got to appreciate him as a person. And after he died, I remember reading some of his opinions for a case I was working on, and it struck me as I was reading the opinion, I could actually hear him speaking, and it occurred to me that he really understood his voice. It was authentic. He wrote in the same way that he spoke. And so voice really mattered to him, words mattered to him, and I'm curious about your own writing, whether you try to carry forward your voice in your opinions. And why don't we start with you, Judge Golgar, on this. How distinctive is your own writing as a matter of language and style and tone? Are there distinguishing characteristics that let you look at a piece and say, I wrote that?
Yeah, that's such a hard question to answer. It's sort of like asking a person what he looks like and does he look different from other people? And I guess I don't usually look at myself. Other people have that questionable privilege. So, I think that the way I write is largely the way I speak. I think there's certain features of opinions that I write, and this was true of briefs too, when I was practicing, that I think are distinctive to me. I'm a huge person for paragraphs. Paragraphs are real things. They have to have a structure. They have a beginning, a middle, and an end, even if it's subtle. And the different paragraphs particularly have a beginning that we like to call a topic sentence, so that the whole thing is kind of a skeleton of topic sentences, and the explanations that are the body of the paragraph kind of hang off that skeleton. And that's the way I like to write, so that you can always tell the purpose of the paragraph from the very first sentence. And then there's another thing that I like to do, and this sort of goes along with ignoring the briefs, and that is the way I'm not one of these people who discusses the contentions of the parties at the beginning, or maybe at all. And what I do is I describe here's why the winner wins. That's the first part of the decision. And then the rest of the decision, I deal with why the loser thinks he ought to win and why the loser is losing. And then when you combine that structure, which I always thought was the best thing to do as a brief writer, make your own case first is a common motto. When you do that and you combine it with this strong emphasis on paragraphs with topic sentences in there, what you end up with, I think, is I feel like I'm patting myself on the back, but you asked. You end up with something that really is muscular, I think. It's bam, 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 you're done. And I think that's great. if I do say so myself. So that particular scheme is one that I always use, and I think it works. It certainly works for me.
Justice Ellis, are there stylistic techniques that you use in your writing when you have to convey a perspective that's intentionally neutral or objective? I mean, you're writing as a court, and if you're not writing in the dissenting voice, you're writing as a panel. How is it that you communicate that neutral voice, if at all?
Well, the way I think of it is I begin a case neutral, and then I evolve to one side. And so I just try to take the reader of the opinion on my little mental journey. I try to start as, it's impossible to be completely neutral in the facts. Well, it's not impossible. It's not impossible to be neutral in the facts. But ultimately, I think you want to start in your. I also, like Ben, will often start with here's what I think and why, and then say the defendant argues this. They cited this case. It's wrong. But I don't think that does any violence to what I'm saying, and I don't think it probably changes what Ben would say about it either. It's still showing neutrality. I try to write in a conversational voice and an unbiased voice because I think that's how my brain got me to the decision.
Well, Justice Tice, let's turn to something that you've done more than the rest of us on this panel, which is to express a dissenting view. And so I'm curious about how, in a dissenting opinion, you might carry more of your voice than in a majority opinion, or not.
Maybe some in between. I completely agree with what has been said here about voice. I call it judicial confidence. Here's the issue. Here's logic. This is the only possible answer. Unfortunately, the losing party here has raised this other point of view, and as I've just demonstrated, the point of view fails, and then try to end the paragraph, that paragraph, try to end the opinion with, try to make everybody feel good about it, I would say. And I try to do the same thing in dissent. I'll start the same way and say, well, this is obviously the correct answer. Logic brings us to this place. And in the dissent that I just pressed send on today, I use words like, unfortunately, my colleagues, are wrong in the way they've seen this. It's as respectful as I can be. Remember, too, I'm still trying to get another vote. I'm still trying to talk to my colleagues, so I'm not going to attack my colleagues. I'm still going to speak in that very neutral voice. I issued a case maybe a month ago that was front page of the newspaper kind of thing here in Chicago, and a number of people have said to me, it's a great opinion, it's really well written, but it was so easy, and the answer was so obvious. And I thought,
that's what you want. It should look that.
It worked on
That's right. Good for you.
to get there, so it looked easy. But I had the same sense about dissent, that how could anyone disagree with me when it is so obvious that this is the correct answer?
We have some individuals in our audience who are law students who may end up being law clerks. I remember when I first became a law clerk, the most difficult thing I think I had to do is to try to learn the voice of the judge. How would the judge say this? And I remember going on to, back then there was no Windows. It was, everything was in DOS. And I was going and looking at Westlaw opinions of the judges that I worked for, trying to get a sense of their voice. And then I clerked for a different judge and had to switch voices. And then later had to come up with my own voice. So I'm curious, how, if at all, do you get your law clerks to write in a style that captures your voice? Justice Tice?
As I say, they've been with me a long time. I think one of the skills of a clerk is to learn how to do exactly this. We'll have a conference. I'll say whatever I say. They give me a draft, and they're literally my words. And then we have these conferences where they all get together, and then they say to each other, that doesn't sound like Judge Tice. This sounds like Judge Tice. So it's a process of learning, and I'm not sure how a new clerk gets there, just jumps into it. It does take some time.
Justice Ellis, do you have any approach you take with your law clerks to help them write like you, or do you just find yourself rewriting everything that they write from bottom to the...
Yeah, I mean, there's a little bit of that when you get started. I inherited law clerks, one of whom had been on the appellate court for over 20 years, and she'd worked for 3 other judges. And she told me within a few weeks, she said, you write differently than all of them. And I said, okay. So I would just keep changing things, and she's now kind of tailoring things. I started with a little manifesto that I wrote of things that I don't like. And you know, it's okay to begin a sentence with and or but, for example. It's not okay to begin a sentence with however. I mean, I've got all these little pet peeves that probably just mine. Well, right. And so they put them up on their little, you know, in their desk area, and they'll look through them, and it's become natural. It is a process. After a while, now they know what I sound like. I'm sure what for Justice Tice is you have the great luxury of having people been with you for so long.
Justice Golgar.
Oh, I wish. Judge, finally. Got promoted briefly there.
Well, so tell us, Judge, something about humor, metaphors, flair, figurative language in a judicial opinion. It's a subject of great debate. I'm curious your perspective.
Well, metaphors and figurative language, something that's colorful, that conveys meaning, I think can be a really wonderful thing and can be a lot more effective than a much more straightforward, plain vanilla approach. So I have no problem with that unless it gets overdone, which can sometimes happen. Humor is another matter, and I am not a fan of humor in judicial opinions. I think Justice Kagan goes about as far as you can go with that. People don't think their legal problems are funny. It reminds me, you know, my doctor is over at Northwestern Hospital, and when I go there, I'm usually not very happy. I don't want to be there. I maybe think something is wrong. And the doctors and the nurses are laughing with each other in the corridor. And I get upset at that. And I know it's where they work. But I'm not happy, and I don't want them having fun. I want them deadly serious and solving my problem. And, you know, we had a judge on the U.S. Court of Appeals here in Chicago who was renowned for, he's a wonderful writer and a wonderful person, a wonderful judge. But he was also very funny, and he allowed this, in fact, I think he took pride in it, to come out in his opinions. And he wrote a very famous opinion involving a dispute, I think it was between two paper companies, and it involved toilet paper. And boy, he just went to town on this. And it was very funny, except you know what? These were two big corporations who paid lawyers a lot of money, and there was something at stake here, and I bet they didn't think it was funny at all. And besides, they manufactured this stuff for a living. I like to remind people of the line from The Mikado, you know, by Gilbert and Sullivan, where the Lord High Executioner sings about the list of society offenders who never will be missed. And one of them is that nisi prius nuisance, the judicial humorist. The occasional pun is pushing it.
Justice Ellis, you mentioned earlier that you had a document that you gave your law clerks to sort of communicate what your preferences are. I've done the same thing. I've got like a 20-page, I call it a manual. It's really my peeves and preferences that I want my law clerks to know to help them to capture my voice. What about you, Justice Tice or Judge Golgar? Can you identify one or two of your more significant peeves or preferences, and how do you communicate those things to your law clerk?
Oh, they get communicated. IRAC. Remember IRAC? Law school? Look at any good opinion. That's how we write, folks. I don't know why, but you know, people think that's what you do in school and you forget about it. There's a reason why we do it. It's a great analysis tool for the kind of work we do. Issue, rule, application, conclusion, clean, strong, logical, powerful, muscular, as you say it.
There you go.
I love IRAC. I'll read a brief and say, well, I don't care what's going on, Bill. That's not. And I'll tell the clerk, help me, IRAC this. That's a verb, which I shouldn't do. But something else, I'm crazed about topic sentences. I have a clerk I'm still fighting about with topic sentences. And finally, no adjectives, no adverbs. If someone says clearly, they lose, because they obviously, or clearly, do not have confidence in themselves.
Judge Golgar, one or two peeves or preferences?
Stuffiness, verbosity, too many words, writing as if you're writing a manual for the operation of heavy machinery. I see a lot of that. Passive voice, although it's not always wrong, but it's usually wrong, and it's easy to avoid. Split infinitives, I'm sorry, don't.
Justice Ellis, give us one or two of your peeves or preferences.
I gave you a couple. I'll give you a couple more. Latin, no Latin. Inter alia, just say among other things. It's the same thing. It's actually in our mother tongue, too. Here's one that maybe others may not say. I don't like footnotes in the middle of a paragraph. Footnotes interrupt a thought. They make your eyes go down. Put it at the end. You almost always could put it at the end with the same effect as where it was in the middle.
One of my biggest peeves, I tell my clerks, no pretentious language, no big flowery words.
Right.
I tell them the rule of thumb is, if it's a word you would have tried on the playground in 6th grade and gotten a punch in the nose from the bully, that's not a word you want to use in the opinion. These are actually two characters I found from 1945 comic. It's Super Judge. And apparently the character is back in his 2014 version of Super Judge.
Still a man.
And it's still a man. Sorry, we're working, yes, but he's got a little ethnicity this time. So, who are your super judges? Is there a jurist, is there a judge either living or no longer with us whose writing style you would like to emulate?
Not Justice Scalia.
Right, I agree.
With all due regard to the late Justice and Brian Garner and others, I think his attack, personal attacks on his colleagues undermines the public's confidence in the integrity of the court system. And I think it's extremely unfortunate. And another way to put this too is, we're talking about color, there's the show-off. These cases are not about us. I'm not here to tell you how clever I am. I'm here to solve real people's problems and to give direction to people to live their lives. And that flippancy is very troubling to me. And maybe I'm vanilla. I like to think I'm ivory. I'm just sort of clean and none of that. I really like John Roberts. I think he has a real clear, direct voice. And just one more thing I'll say quickly. I've been reading some Supreme Court cases. I read Brown versus Board of Education a while ago. Chief Justice Warren's opinion is 12 paragraphs long. Changed this country in 12 paragraphs. It's amazing. Yesterday I read his opinion in Miranda. It's the biggest mess I ever saw in my whole life. So, there you go. Different one.
Judge Golgar, heroes?
Well, I have to be careful because I'm appointed by the Court of Appeals here, and I'm up for reappointment right now. So I'm just going to take them totally off the table and not talk about any of those people. Despite what I said about the way she uses humor, which actually I think she's pretty funny, I like the way Justice Kagan writes. It's very conversational. It's very simple and easy to understand. And to pick a name that I don't know how many people have heard, Judge Gorsuch on the 10th Circuit is a fabulous writer. He does beautiful work.
Finally, Justice Ellis.
I do think that John Roberts is a very good writer. I do like his writing. Not commenting on the rulings, but the writing is very precise, and he picks his spots when he wants to make emphasis. I remember he had one opinion where he was talking about how the government had no answer for something. And he said, to this the government says, dash, nothing. And I thought it just so perfectly punctuated that their silence was so deafening. I also like Diane Wood from the 7th Circuit a lot.
Our time is up, but if we could, just for 15 seconds, each of you, we've got future law clerks, we have judges, we have academics who teach future law clerks. If you could give one 15-second piece of advice on judicial writing, what would it be? Start with you, Judge Golgar.
Well, all writing, really, I'll go back to what I said. Organization is key. Flow is key. You achieve that by thinking paragraphs and by using topic sentences.
Justice Tice?
Structure, legal framework, topic sentences.
That's the spirit.
Suggestion or advice?
Master the facts before you get to the law.
And one piece of advice I'll give you, read your drafts out loud.
Yeah.
Please give a warm applause.
Yeah, that will. I haven't been so. Have fun on your trip, man. Have you been cutting?